Welcome to this installment of Clarifying Tax Situations with attorney and CPA David W. Crossing.
How would entering into a domestic or international voluntary disclosure help me fix my prior year cryptocurrency noncompliance? If you have several years of cryptocurrency noncompliance, okay, from as far back as possible 2009 forward, and there's large amounts of taxes that went unpaid, and there's lots of badges of fraud in your fact pattern. A badge of fraud is anything that if the government looked at it, they'd think you acted fraudulently because of that evidence, okay? Well, a pattern of noncompliance over a long period of time tends to establish willful behavior. Willful evasion of income taxes is a felony. It's 3 to 5 years in jail for each year it was done. There's a 5-year criminal statute or a 6-year statute, depending on which one they're relying on. And significant jail time could be involved in this. The good news is I have a way to fix it. There's a program, or let's call it a policy, because that's really what it is. The IRS has a policy. If you come forward to them and you admit your tax fraud, okay, before they've approached you, in other words, they had no idea there was a problem with your prior tax filings, you come forward, you admit that there's something wrong with your previous tax filings. It could be as serious as you openly and intended to commit tax fraud. If you come forward to them and admit it and set out to fix it and make a true, accurate, and complete voluntary disclosure, you will get a pass on criminal prosecution. This is amazing, because think about it. If you murdered somebody, there's no government program to bring the body back to life and get an excuse for murder or get forgiven for murder. In nomine patria, I forgive you of your sins. But with tax fraud, this is possible. Now listen, this is not to be entered into lightly. This is a one-way decision. You need someone who understands this program to walk you through it. Okay, so how does it work? Well, it kind of goes like this. I go forward to the Internal Revenue Service, knock, 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 Criminal Investigation Division of the IRS. I'm bringing forward a client whose actions, if you looked at, you could potentially believe they were committing fraud. If possible, I'm going to argue, that if you really didn't have fraudulent intent, you may have been grossly negligent. But bottom line is this: even if you admitted to fraud, you get a pass on criminal prosecution if you use this program. So what's involved with that? The first thing I want to tell you is you need to be very careful. The person you go to for help can be your worst enemy. Think about it. CTEC certified folks, CPAs, enrolled agents, they don't have attorney-client privilege. They could literally be forced to testify against you under a court's contempt power. What can the court do to them? Sir, you're going to go sit in a jail cell for an indefinite period of time until you're willing to answer the court's questions. Sir, I'm going to fine you $5,000 a day until you start answering our questions. All within the court's contempt power. Believe me, they're going to sing. If you're a CPA, enrolled agent, or CTEC certified preparer, if someone walks in your office and they start talking about tax crimes, you need to kick them out of your office as soon as possible. Tell them to go see a tax attorney. If you haven't worked with this person before, tell them to tell the tax attorney they've got a relationship with this enrolled agent, CTEC certified, whatever. You can be involved as long as you don't know too much, okay? It's possible to associate in an accountant under something called an attorney's Covell relationship with an accountant. Under a case versus Covell versus the commissioner, long and short, it's already settled law that if somebody is providing a legal service to a client, helping a tax attorney, for example, quantify prior year possibly criminal noncompliance, that this is the provision of a legal service. And if there's a Covell relationship between the accountant and the attorney, or the preparer and the attorney, the accountant or the preparer can be under the same attorney-client privilege as the attorney has with the client. Although the very purpose of making a voluntary disclosure is to prevent prior year noncompliance from becoming a criminal tax issue, again, it's very important that a criminal tax defense attorney be brought into the case from the very beginning on lots of grounds, not just attorney-client privilege. Frankly, you need to understand this program inside and out, and I'm sorry, this isn't work that CPAs, EAs, and CTEC certified folks should be doing without the direction and control of working with actually for an attorney to serve as a client. The first thing that needs to happen is the attorney needs to make an assessment of a client's potential to be criminally prosecuted in the first place. If I come in and I look at a client's prior non-compliance and the amounts at issue are small and there are no badges of fraud in the fact pattern, I might be able to save that client from taking on the full expense and stress of making a voluntary disclosure by just recommending amended returns be submitted to a service center where I don't believe there really are badges of fraud in the fact pattern. In other words, I believe negligence caused the problem and not criminal intent. That is legal work. This is not something that EAs, CPAs, and CTEC certified preparers are trained to do. They're not trained to gauge somebody's criminal intent to their actions or whether they're willful or non-willful. That is attorney work. If you have somebody that's tried to do that for you that's not an attorney, they're basically practicing the unauthorized practice of law and you could have their license. The first process in a voluntary disclosure is I send off a fax. If there's a married couple involved, it has both the names of the couple, it has their social security numbers, it has their birth dates, it has their address. Enough information for the government to identify these individuals positively, their social security numbers, and it asks a simple question: do these folks qualify to make a domestic voluntary disclosure, or if there's offshore issues, an offshore voluntary disclosure, sometimes both. It ordinarily takes the government 4, 6, 8 weeks sometimes to respond to this initial pre-check. They're going to come back and say one of two things. Yes, your client qualifies, in which case you can move forward with the voluntary disclosure, and in my opinion, they're as good as entered into the program, okay? Or no, your client doesn't qualify. If that happens, watch out. In the 2 times that's happened with one of my clients, the government was already criminally investigating them, or something was going on in the background while they had information on them and they didn't qualify to make a domestic voluntary disclosure. Remember, we said that the only reason this works is you're approaching them before they know anything about you. If they're already looking at you in the background, even if you haven't received any mail, you may not qualify for this program.